A major metaphorical gunfight is taking place over your right to keep and bear arms in the United States Court of Appeals for the Second Circuit in New York City in a case called Zherka versus Garland. We have to talk about some supplemental briefing that just came in involving whether or not nonviolent felons have the right to keep and bear arms. This is the next frontier in the battle for our rights after the U.S. Supreme Court decision in Rahimi. Let's break down the arguments made by the Department of Justice as to why they want to be able to take away your right to defend yourself. Let's talk about it when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Attacks Teach Americans About the Right to Bear Arms. A lot of important international information in there about our right to keep and bear arms, as well as historical. Check it out on Amazon if you have the moment. All right, folks. So, after Rahimi, U.S. Supreme Court decision, the anti-gun Department of Justice is trying to take away our rights, as you knew they would. Don't think it's going to work for them. And this, to illustrate the point, there is a case that may be on the way to the U.S. Supreme Court. We'll see. Pending in New York City right now. The name of the case is Zherka versus Garland, and it deals with a man who was convicted, I believe, of some sort of white-collar tax-related crimes and became a felon. And under 18 U.S.C. 922 G1, because he was a felon as defined by that statute, he is disarmed for life. He brought a lawsuit against Merrick Garland and the anti-gun Biden administration, claiming that this lifetime disarmament provision of 922 G1, simply because he's a nonviolent felon, unconstitutional under the Second Amendment. And this case has been argued in New York all the way up to the U.S. Court of Appeals for the Second Circuit. An argument took place recently, but of course now we have arguably a development, which is the U.S. Supreme Court came out with a decision involving one aspect of federal gun control law 922G, not 922G1, 922G8. So what's going on here is the U.S. Court of Appeals for the Second Circuit asked the lawyers to submit briefs as to whether or not they thought the U.S. Supreme Court decision in Rahimi impacted Mr. Zherka's claims under the Second Amendment that he cannot be disarmed because he's a nonviolent felon, and it's simply unconstitutional to take away his gun rights for life because he is quote-unquote a felon where there is no finding or any evidence he was a violent danger in any respect, which is a dramatic inconsistency, or dramatically different, of course, from the record of Zaki Rahimi, who was engaged in like 5 or 6 different shootings. He took his girlfriend's head and hit it against the dashboard. He saw a witness that witnessed this and shot at the witness, and so on and so on. Much different fact pattern for Mr. Zherka than it was for Mr. Rahimi. So anyway, there is back and forth going on. I'll try to put links to the docket of the Zherka case. You can check out these supplemental letter briefs that were going back and forth, but there's a few interesting points that were made. Specifically, the Department of Justice is really, at the end of the day, if you want to look at their argument, it distills down to the following. Their argument is that if you look at the Rahimi case, the Rahimi Supreme Court, or Supreme Court in Rahimi, said that because, and you're going to see the faulty of the logic here, the logic's not going to fly, but you got to understand the logic of the Department of Justice. Basically, they're saying that because the Supreme Court pointed out that people who had misused firearms or who were found to be a potential threat for misusing firearms could go to prison, it was okay to simply disarm them. And DOJ takes it to the next level and they say, therefore, if at the time of the founding you could be imprisoned or you could be executed, meaning put to death, for nonviolent crimes, by extension, we at the Department of Justice and we Congress can take the lesser step of disarming you, because if at the time of the founding we could put you to death or put you in prison, we certainly today can simply disarm you, which is a lesser penalty or lesser punishment than being imprisoned, and it's a lesser punishment, of course, than being put to death. And because at the time of the founding, DOJ argues, there were crimes that you could go to death or be put to death for that were not violent, by extension, we can disarm you for nonviolent felonies today in the 21st century. That's the Department of Justice argument. If it's true for the greater, it's true for the lesser, is basically the argument. Now, that does not fly here for several reasons. First of all, if you look at the Rahimi case carefully, what distinguishes Rahimi from Mr. Zerka is that Mr. Rahimi was found specifically with findings of fact by a court to have misused and to be a threat to misuse firearms, specifically. The Rahimi decision does not say that because Mr. Rahimi was a threat to commit bank fraud, or because Mr. Rahimi was a threat to commit tax fraud, or because Mr. Rahimi was a threat to commit some other white-collar crime like lying to the FBI a la Martha Stewart, you can disarm him. No, it's very, very precise. Because Mr. Rahimi was found by a court to pose a credible, violent, physically violent threat to another person, in this case his girlfriend, or ex-girlfriend, he could be disarmed. Now, the reason why the argument by the Department of Justice doesn't fly and is not supported by the Rahimi argument is in addition to the fact that Mr. Zerka was never found by a court ever to be a violent threat to anybody in any context. Remember, Mr. Zerka at most was a white-collar criminal that committed tax fraud or whatever that kind of white-collar crimes are. Not a good thing, but certainly nothing to do with violence. So the first thing is Mr. Rahimi was found to be violent. Mr. Zerka was never found to be violent. That's the first distinction. But it goes beyond that. Let's specifically talk about this argument by DOJ that says that if we could put you in prison or put you to death at the time of the founding for a crime, we certainly could take away your guns today because it's a lesser penalty. No. Because what Rahimi found was that the reason why, hear me carefully, it's very important, the reason why you could be disarmed temporarily, i.e. Mr. Rahimi could be disarmed temporarily, was because he was specifically found to be a danger with a firearm. The risk posed, as found by the court, was that he was viewed as a threat to another person for or involving the potential misuse of a firearm. And because at the time of the founding, if you were found to be a threat of misusing a firearm could lead to imprisonment, by extension, they said, you could be disarmed today. Because if you're found to misuse a firearm at the time of the founding, you could go to prison. And therefore today, if you're found to be a risk of misusing a firearm today, we can disarm you. Okay? This is totally different than what the Department of Justice is arguing. What DOJ is trying to say, again, is nonviolent felons at the time of the founding, you could be put to death, and therefore we can take your gun away today. No, this is not the same. The difference is that the exposure to imprisonment was for a reason other than the risk of misuse of a firearm. You see what I'm saying? That the Rahimi decision by the Supreme Court focuses on the potential or actual misuse of a gun giving rise to disarmament. They did not say that simply because at the time of the founding you could be put in prison or put to death because of some generic law, that's enough to disarm you today. No, it's because Mr. Rahimi was found to either be a threat to or to have engaged in misuse of a firearm, and as a consequence, the penalty or the preventative justice aspect of the finding of the potential or actual misuse of a firearm was you could be disarmed. That is different what DOJ is trying to say, which just says that any crime at the time of the founding where you could be disarmed, where you could be put to prison, allows us to disarm you today. No, the key is it's got to be about the causal connection, that you are a threat to misuse a gun or you have misused a gun, is step one, and the consequence of that, right? The antecedent is you threatened to misuse a gun, or you found to be a threat to misuse a gun, or you were found to have misused a gun. That's the antecedent. The consequent is, as a result, we can disarm you. Okay? It is not what the DOJ says, which is if there's a crime at the time of the founding where you could be put to death or you could be imprisoned, therefore you can be disarmed. No, it's not the same thing, because the touchstone, the key crux of this is that it's the exposure to going to prison at the time of the founding because you were a risk of misusing a firearm, which was the key factor. So here is what the lawyers say on behalf of Mr. Zherka. It's very articulate. It's essentially what I'm saying here. Let's turn to the scoreboard. To be sure, Rahimi engaged in a form of greater includes the lesser reasoning, stating that if imprisonment was permissible to respond to the use of guns to threaten the physical safety of others, then the lesser restriction of temporary disarmament that Section 922G8 imposes is also permissible. But that reasoning does not help the government here in the Zherka case, because whatever the reasons for authorizing a prison sentence for Zherka's offense, they are wholly disconnected from any risk of his using guns to threaten the physical safety of others. And that sinks the government's case by suggesting that the only disarmament regimes to continue past the adoption of the Second Amendment were those targeting individuals who physically threatened others. The Rahimi case by the Supreme Court adopted a reading of the available history that does not support disarming Zherka on the basis of his conviction. Again, as you can see, the crux of the argument as to when you can be disarmed is, have you misused firearms, or is there a viable finding that you're a credible threat to misuse firearms? That's the key. It's not that there's a crime at the time of the founding that you could have gone to prison for or could have been sentenced to death for, and therefore that same crime today allows you to be disarmed. No, it all turns on the misuse or potential misuse of specifically of firearms. That's the key, and that I think is what the Supreme Court will agree to. We'll see what the U.S. Court of Appeals says in the Zherka case here. Again, if the Second Circuit decides the Zherka case in the next month or so, this is a case that could potentially go to the U.S. Supreme Court next term to interpret whether or not nonviolent felons can be disarmed for life for things that have nothing to do with violence and nothing to do with the specific misuse of firearms. Because again, while Mr. Rahimi misused a firearm, and that's what got him disarmed, Mr. Zherka has been disarmed simply because of some sort of a mail fraud, tax fraud conviction, totally unrelated to anything involving violence and totally unrelated to anything involving alleged or actual misuse of, for example, a firearm. All right, folks, hope you learned something here today about the Zherka case and the nonviolent felon issue. Make sure you subscribe to this channel. Don't forget to follow me on X at 4Boxes Diner, and we'll see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.